projects by European organizations. And what we see in those cases is a combination of several factors. So first, a broad understanding of what counts as personal data, and this also means the scope of application of the GDPR. A rejection of the so-called risk-based approach to how organizations should assess whether they're complying with GDPR data transfer. In other words, push towards what we call zero risk. And European organizations are effectively required to eliminate the of US government access to European personal data, and that's simply possible for most digital services that process data and not merely offer data storage, which is really encrypted. And what ICE is actually about, and this is that it is impossible for anyone, including the data protection authorities themselves, to eliminate the risk of US government access to data that goes between strictly European entities. The US government is being high foreign networks under executive order 1233, and there will always be a non-zero possibility of that. So this raises the question: what's different to the actors just a subsidiary of people? The likely consequence of this is that if the current US data framework falls apart, it will no longer be business as usual, or at least I suggest so. And what is at stake is whether US companies will be able to provide many of their digital services to European customers at all. And if they seriously those developments I just mentioned, may very well be that no kind of data localization and no other measures will satisfy the interpretation of the GDPR. Let's take a step back and remind ourselves why the issue of EU-US data flows is really important. This brings us to GDPR Article 44, and under that provision, transfers of personal data to countries, and what can happen under conditions set out in the GDPR. Otherwise, the transfer is illegal. Several legal grounds to make transfers lawful. Without going into too much legal detail, it is going to say that the conditions for lawful transfer could be rather strictly. This is especially true for the so-called derogations, but for the rather contractual clauses, which are governed in the commercial context. And this new enforcement way, which I mentioned a moment ago, that put on this case as one, which is very hard to get clauses. So this means that it may be that for some important clients for data processing to some involves a third country, only an adequacy system from the harbor. And according to Article 45 of the GDPR, and an adequacy decision, the European Commission designates a third country, territory, or one or more specified sectors within a third country, which ensures an adequate level of protection of personal data. And when an adequacy decision applies, there is no additional authorization and for data transfer. What we are discussing today is the question whether the most recent adequacy decision of the US will allow by the EU courts to stand. In July 2020, the Human Justice decided that the pre-GDPR adequacy decision for the EU-US Privacy Shield was Schrems 2. Without going into the somewhat complicated history of this decision, this case originated in a dispute between Schrems and the Irish Data Protection Commissioner regarding the interface and their data transfers. Schrems is crucial for the discussion because it provides guidance on interpreting the GDPR's standard adequacy of data protection for the practice. As I stressed, however, that frustratingly, the judgment doesn't provide all that much guidance to what adequacy means. In Schrems 2, the court decided that US law and practice allow limitations to protecting personal data, which were not circumscribed enough. For instance, the rules on bulk collection of data didn't have clear and precise limits and safeguards. And in addition, the court held that EU persons did not have access to effective judicial remedies against potential overreach by US authorities. While validating that all adequacy decision, the court did not preclude the possibility of using such a contractual clauses by businesses, but we already know the later history of enforcement that seems to be increasingly closing that adequacy. Responding to that gap created by Schrems 2 and the interpretations of that decision pushed by some big jurisdictional authorities, the US and the EU side negotiated a new framework. As a result, we had several legal changes on the American side, including the agreement by the order 14086 last year. And on the EU side, we have the adequacy from this. There are many new aspects of this US framework, but I wanted to highlight some that most directly aim to address the key concerns from Schrems 2. So regarding the scope of US government collection activities, the executive order defines legitimate objectives for signal intelligence and includes express references to necessity and proportionality in the process of applying those objectives in practice. And I'm sure our panelists will have much to say about that. Regarding redress, there is now a new structure with a securities protection officer, new data protection report, which is meant to be independent and to have legal power to be binding decisions that other US authorities must obey. Naturally, the EU Commission's adequacy decision concludes that this new US framework satisfies the GDPR's standard of adequacy. Not everyone agrees. The European Commission that the US framework is adequacy standard. I know of two legal challenges which that were already announced. So the first legal challenge we already filed is adequacy decision. It is from a member of the Parliament and a commissioner of the Protection Authority in Finland, decided to lodge a direct action for annulment under Article 63 of the Treaty on Functioning of the European Union, which means that this case very strict visibility conditions to the extent that one may wonder if it's just a publicity and because on existing precedent on the legal side, it will not clear the bar of visibility. But if we succeed with standing, then this may be a faster procedure. But it's not describing this is just with standing. Max Schrems, surprisingly, plans to bring a legal challenge against the adequacy decision, and as he has done successfully in previous cases. However, this time he is still fighting the Irish courts, and he has to still begin a suit, rescue courts in Austrian courts, hoping for a speedy preliminary reference to the EU Court of Justice and we know, so there is a question. It may take several months for the Austrian courts, then on average 17 months for the Court of Justice to decide on the reference. So in any case, we're definitely looking at least 2 years for this to play out. The rest is to the legal argument likely to be significant in those future challenges to the adequacy decision. I identified those arguments based on public statement from Schrems 9 organization and also based on recent academic publications. I will start with the fundamental question about the meaning of the applicable legal standard, that is adequacy, and then I will consider the functionalities, the principle of data collection, then effective judicial redress, and finally I will look at access to information about data processing. Given that the point of an adequacy decision is to decide their country towards a level of protection of personal data, another question is what does that mean? What is adequacy? Under the old data protection directive before the GDPR in Schrems 1, the court clarified the word adequate in the context of third country transfer saying that it does not mean identical level of protection, but there is a means level of protection that is essentially equivalent to that in the EU. The GDPR followed that approach from the Schrems decision, and as Article 45, containing the word adequate, but recycle 104, or also wrote the words essentially equivalent from Schrems 1. And in Schrems 2, the court did not say much more about the standard adequacy. So we are still in a position where we know that it doesn't remain identical, but the court would like me to provide more clarity when deciding on the adequate challenges to the adequacy decision. Moving on to the question of proportionality, the legal framework comes from Article 52(1) of the EU Charter of Human Rights. And according to that provision, restrictions of rights like the rights to privacy and the protection of personal data must be several conditions. They must be provided for by law and essence of the rights. Moreover, subject to the principle of proportionality, limitations may be only made if they are necessary. The objectives recognized by EU law or the need to protect rights and freedoms of others. Thus, one of the key questions is whether the restriction of the rights in question pursues one of the objectives recognized by EU law. In his comments on the EU US framework, the court argued that the legitimate objectives listed in the executive order are too broad and that they could be interpreted to include, for example, criminal or economic threats which do not rise to the level of national security concerns as defined by the Court of Justice in sort of intra-EU cases. One potential issue with this argument from court is that the legal guidance we have on the issue of legitimate objectives is in the context of internal EU matters. We don't have direct guidance to question legitimate objectives or adequacy decisions under Article 45 GDPR. Another relevant point is the one that the Commission makes in the decision. The list of the objectives in the executive order itself is only the start of a process of concretization of objectives into signals, intelligence priorities, and this process is meant to ensure compliance with the applicable legal requirements, including those relating to privacy and civil liberties, as a quote from the decision. So, focusing too much on just the list of objectives in the executive order may constitute a new formalism. The US data protection framework should be assessed as a whole. But even if they pursue a legitimate objective, some signals intelligence activities tend to be viewed by the EU court as especially invasive. And the key example of that is indiscriminate collection of contents of electronic communications, or argues that the executive order does not preclude indiscriminate collection of e-communications content data, violating the essence of the rights to privacy and personal data protection. The violation of an essence of the right is always prohibited. That's the end of the proportionality analysis. Such argument could be made. In its opinion on the draft adequacy decision, the European Data Protection Board responded to some concerns by noting that the CDU did not exclude by principle bulk collection, but considered in its Schrems decision that for such bulk collection to take place lawfully, sufficiently clear and precise limits must be placed to limit the scope of such bulk collection. And the European Commission framed their response to the adequacy decision with a distinction. So first they said that collection of data within the United States, which is most relevant in the adequacy decision, must always be targeted. And bulk collection may only be carried outside the United States on the basis of the Executive Order 1233. And I'm guessing that this likely refers to an argument made, for example, by Theodore, that adequacy assessment should only concern the processing of personal data due to a data transfer in the country in question. So the concern of domestic surveillance in the country, not international surveillance in the country outside of that very country. The Commission added that bulk collection under Executive Order 12.3 takes place only when necessary to advance specific validated intelligence priorities. It is subject to a number of limitations and safeguards designed to ensure that data is not accessed on an indiscriminate basis. So bulk collection is important in contrast to a collection taking place in a generalized limited map surveillance without limitations and safeguards. So on the Commission's view, there is a categorical distinction between bulk collection as practiced by the US and the generalized indiscriminate mass surveillance that the CJU scrutinized in Digital Rights Ireland and other cases. And this may seem like a natural reading of generalized and indiscriminate, given that it is meant not to apply to collection of large quantities of signals intelligence due to technical and operational installations and so on and so on. However, there may be analogies in EU law that we and the Court of Review Commission, I at least thought about the case collection yesterday. So, which dealt with the court's interpretation of the prohibition of general monitoring obligations from Article 51 of the e-commerce. And in that, interpreted this law as not precluding member states from requiring hosting providers to monitor all the content they host to identify content identical to the content of information which was previously declared to be unlawful. So in other words, general monitoring in that case was interpreted as not covering indiscriminate processing of all data stored by a hosting provider to find content identical to others. And the court adopted an analogous approach in respect to Article 17 of the Copyright Directive. So this suggests that in somewhat similar contexts, the court is willing to see activities that may technically seem general as not general if some skills that substantive limitations are present. The lack of effective redress available to EU citizens against potential restrictions of the right to privacy from US intelligence activities was central to Schrems 2, as I mentioned before. And the new executive order introduced a new redress mechanism that includes especially the new data protection review court. In a recent public debate, Max Schrems argued that the CJU would find it difficult to find that this is a judicial procedure that satisfies Article 47 of the EU Charter, while at the same time holding that some courts in Poland and Hungary do not satisfy that requirement. I think that Schrems raises two distinct issues. First, Schrems seems to suggest that an adequacy decision can only be granted if the available redress mechanism satisfies the requirements of the Article 47 of the Charter of Fundamental Rights. And this may be the case in Schrems 2. The court did not say that Article 47 determines the required protection. The court said that Article 47 contributes to the required level of protection. Maybe this is it does look like these are distinctions determining and contributing. And this would mean that if only essential equivalence is required, perhaps Article 47 does not apply fully and directly, but with some accommodation. And the second issue is whether the new reverse mechanism is effective under the applicable standard of required level of protection. So Versakis, Professor Swire, in their paper offered a very helpful analysis suggesting that it is, considering the proposed GDPR independence, effective investigative powers, and authority to issue binding determinations. In response, Gorski and Korf, among others, argued that this is not the case because the EPICENTER is not wholly autonomous and free from hierarchical constraint. And Gorski, in a number of papers, also argued that the US president can overrule the DPRC in secret. And however, even in the scenario sketched by Gorski, if that's theoretically possible, this overruling in secret, the CJU may take the view that it would not be appropriate to rule based on the assumption that the US government would act to mislead the EU by secret changes in the law. And without that assumption, I would suggest that the possibility of future changes to US law can be addressed by the adequacy monitoring process, right? If you don't make the assumption of secret change to the legal frame. Max Schrems also argued that it may be practically impossible for EU persons to benefit from the new redress mechanism due to the requirements imposed on qualifying complaints under the executive order. Presumably, Schrems implicitly referred to the requirements a complaint, quote, unless it's a covered violation has occurred that pertains to personal information or about the complainant, not the person reasonably believed to have been transferred and so on. But however, the same provision also states that the complaint should include, quote, information that forms the basis for alleging that the covered information has occurred, which need not demonstrate that the complainant statement has been subject to United States intelligence activities. So, given the qualifications that a complaint only need to allege the violation and need to not demonstrate the complainant's that the complainant's data has in fact been subject to US signals intelligence activities, it's not clear to me what is the basis for Schrems' suggestion that it will not be possible for EU persons to validly bring such complaints and their benefit from the US mechanisms. Schrems' organization NOIM also raised a concern that both German by court is always spelled out in the executive order, and this concern seems to be based on the view that the decision of the DPRC, the judgment, and what the DPRC communicates to the complainant are not, so they consider that they are the same thing. In other words, the legal effects of the DPRC decision are exhausted by providing the individual with a neither confirm nor deny statement set out in section 3 of the executive order, and this is clearly incorrect. The DPRC has the power to issue binding directions to intelligence activities. We know that from the executive order. So the actual binding determinations of the DPRC are not predetermined by the executive order, only the information to be provided by the complainants. And in this sense, Core in this quote is right in his comment that boilerplate responses do not constitute the judgment reached. But I'm not sure like he thinks has a consequence. He thinks it does. So this is not necessarily the problem, right? Because there's still a binding determination. Just information about the binding determination is not communicated, and these are separate issues. So about that information, there may be a question of access to information about data processing by US authorities. In a relatively recent judgment, the Court of Justice looked at the difficult problem of notifications for persons whose data has been subject to state surveillance, requiring individual notification, but only to the extent that, and as soon as it is no longer liable to jeopardize the law enforcement tasks in question. So, would even such limited individual notification be required from a very country under the adequacy standard? Perhaps not, given that adequacy does not mean identity. Also, it may be relevant, I think, that EU member states restrict very significantly access to information about data processing for law enforcement and intelligence tasks. And this is well described the European Union Agency's fundamental rights report on surveillance by intelligence services. So this may not be definitive for establishing the standard of adequacy, but perhaps it should count. And we should also note that the Commission concluded that EU person may have access to information about data processing. So they didn't take this box in a sense by saying that we have access, or that she has access to the US Freedom of Information process, FOIA, albeit with restrictions, but then there are restrictions in Europe, perhaps that satisfying this requirement. In conclusion, my main conclusion is that it is incorrect to say that the result of the upcoming challenge is clear. under Schrems. For me, the result is quite difficult to predict. And the court will not be able simply to apply Schrems, so it will have to say more about the standard of adequacy than it said so far. And in its adequacy decision, the European Commission presents a sophisticated, I would say, yet uncynical picture of the US law and practice. One prominent example of this uncynical approach is the Commission of the Independence, the DPRC. The DPRC adjudicated process. The lack of cynicism will likely be seen by some as naive or unrealistic, even if this realism is based on speculations of what might happen, like those secret changes to US law, rather than evidence. So litigants will likely invite the courts to assume that the US government cannot be trusted and that it will attempt to mislead the European Commission and thus undermine the adequacy monitoring process under Article 45.3 GDPR. So, however, it is unclear to me whether the court will be willing to go that way, not least due to respect for comedy in international law.
Fantastic. Thank you so much, Nikolai, for a very detailed introduction to the topic. In terms of the next part of the discussion, I'm delighted to have three expert speakers on the panel who will share their own take on the issue. And I'm very happy to welcome first Theodore Christakis to the panel, who is a professor of international law at the University of Grenoble and also the director of the Center for International Security and European Studies. Now we're going to move to Bianca Iola-Marco on our panel, who's a policy manager for global privacy at the Future Privacy Forum, and her work very much focuses on growing the footprint of her organization, not just here in Brussels, but across the globe. And then last but not least, we're going to go to Willie Upheld, who is a partner within Bird and Birds Technologies and Communications and Data Protection Group based in Paris. And he provides assistance to companies, governments, and authorities on complex regulatory and contractual matters. So very much topical for our issue. And I'd like to move to Theodore first and kind of continue with the academic interpretation of the issue, right? Because it's all about the precise and rigorous definitions that essentially help us to understand these different viewpoints. But do you think we have got enough clarity after the Schrems 1 and 2 and now the adequacy decision by the Commission? Or do you think that a potential third court case on this issue would be helpful to clarify it further? So Theodore, over to you.
Thank you very much, and thanks for the invite. Many thanks to Nikolai, especially for this very clear presentation, really focusing. It was really very challenging on some of the most important issues and the most important challenges to be discussed. And I was a little bit concerned that you would just throw the grenade, launch the grenade into the room and let us diffuse them. But I think that he made a lot of very interesting comments in starting to diffuse a little bit, all these issues and to clarify them precisely because when in my introductory comments, unfortunately, you only gave me 7 minutes, and the first one is almost gone. I will not be able to comment. Unfortunately, I hope that we'll come back because I will have a lot of comments to make on some of the main issues that you raised. But the issue of clarity that you mentioned, I think that it is absolutely essential. This is what I was saying in Luxembourg during a similar conference last week, that there is a real need for clarity on these issues. There is a real need for expertise. There is a real need to have an adequate methodological approach to compare apples to apples and oranges to oranges, because otherwise, these issues are extremely complicated, even for people who are working hard on them. All the issues concerning government access to data for national security or law enforcement purposes are extremely complicated and really challenging. And if we don't do this effort of thinking and of clarifying things, of being pedagogique, as we say in French, then there is a tendency, to have a kind of dogmatic approach to lump all the issues together, and this could lead to mistakes. And unfortunately, I think there are a lot of misconceptions, there are a lot of misunderstandings, there are a lot of confusions, and even when you read judgments like Schrems 2, for instance, there are some things that are not entirely clear sometimes. I would mention some of them afterwards. So there is a real hard work to be done, I think, in the way to Schrems 3. And one of these issues is to try to understand what this case is about. And we often, it was a very caricatural way of presenting things. In Schrems 2, there were two issues. One was the proportionality issue, the other was the regress issue. Things are so much more complicated than this, because under proportionality, in reality, you have plenty of different things, and proportionality is only one of the 5 components. And we see, for instance, I might be able to come back later, that the Court of Justice itself in Schrems 2 conflated the principle of legality and the principle of proportionality. This is not satisfactory, because I think that we need to take the issues in order and try to address each issue separately. As a matter of fact, we said that also this is a case about Article 7, Article 8, and Article 47. And I also disagree with this. It's not the case about Article 7 and 8 on the one hand, and Article 47 on the other. It's a case about Article 52, paragraph 1, which is about the permissible limitations to these rights, which are recognized by Article 7 and 8 on the one hand, and Article, not 47 as a whole, but just Article 47, paragraph 1, which is the right to effective remedy, and should not make a confusion with the right to a fair trial under Article 47, paragraph 2, which concerns, for instance, the tribunals in Poland, etc. I think that we should not make confusions between the different concepts and different rights. It is very important to think about this case as it is, which is we're talking about government access to data and about permissible limitations under Article 52, paragraph 1 to the rights recognized by the Charter. And not only this, but even these permissible limitations must be read under the prism of essential equivalence. And as Nikolai said, and we have organized CPDP panel, which you can listen to in YouTube. It was a great CPDP panel last May. And as all great CPDP panels, I serve here the organizer of CPDP 2022. A great conference, and we organized a panel with Peter Schweier and Gupta and Nora Minoden, where we discussed precisely this, and we tried to show how right was the approach of the Advocate General in Schrems 2, where he excellently summed up his point, and he said that we should not necessarily expect comparative countries to meet the particularly high standards of EU law, that some flexibility was necessary, and that cultural pluralism and differences in the legal systems should also be taken into consideration. The whole panel was a discussion about this, which is very important, because you see, for instance, the EPP positions on the adequacy decisions, not only concerning the US, but also South Korea, Japan, the UK, of course. Well, the UK is closer, but if you see, you will see that there were a lot of problems, not only with the UK surveillance laws, but also with the other ones. But still, we understood that there are differences in approach, that there must be some flexibility. This has been recognized. There have been no challenges from what I know to South Korean, for instance, or Japan adequacy decisions. So we only focus on the US, but we should a little bit make comparisons, which could be very interesting, because it's true, for instance, in the US, there is no proportionality concept, that this has been introduced. We'll be able to discuss it later, I hope, more in detail. But as a matter of fact, there are some strong traditions that also must be taken into consideration. They're not necessarily the same kind of the traditions concerning oversight as in Europe, because you have a very strong culture of internal oversight, while in Europe we are much more focused on the basis of the case law of our two courts on independent oversight. But I think that this is something that somebody must take into consideration. I will make precisely a last slide. I see 7 minutes, just too small, to talk about the case law. Another very interesting thing is to try to find out what is the relevance of the case law of Strasbourg, of the Court of Strasbourg, the European Court of Human Rights, concerning the interpretation of Article 8, and especially paragraph 2 to Article 8, about the permissible limitations to the right of privacy. As a matter of fact, we know it is the position of the Court of Luxembourg this time about this. They even repeated it last year in a judgment where it was said that for the purpose of interpreting the Charter of Fundamental Rights, account must be taken of the corresponding rights of the European Convention of Human Rights only as the minimum threshold of protection. So some people were very fast to say that, well, the Court of Luxembourg was right not even to mention the case law, the huge case law of the European Court of Human Rights concerning surveillance. It was not even mentioned once in Schrems 2, as we know, because this is not relevant. And I strongly disagree with this, and I think that this kind of approach is precisely what we're talking about, lack of clarity and confusion, because the case law of the European Court of Human Rights is absolutely relevant in at least 2 respects, and they're very important. I will finish there. The case law of the European Court of Human Rights, its interpretation of Article 8, it's absolutely relevant in situations which are not covered by EU law. For instance, concerning direct surveillance. Okay, we're going to come back. Direct surveillance is what? Direct surveillance, as it is opposed to compelled access, is a situation where an intelligence agency undertakes itself, does not request data from the company, this is the hypothesis of compelled access, but undertakes surveillance itself. And as Nikolai said very correctly, stating also the condition, this can only take place under EO 12323. We will come back, I hope, and discuss this and clarify this, outside the United States. Well, this is not covered by EU law. The case law of the Court of Luxembourg is clear here, and even the Advocate General in Schrems 2 said, sorry, this is not covered. Direct surveillance is not covered by EU law, because it would have the national security exception in the Charter and all the instruments within the GDPR. So this is a matter where the only guidance that we have is the guidance coming from the European Court of Human Rights, which is 100% relevant. The second situation is a situation related to the interpretation of concepts and terms which are found in the Charter of Fundamental Rights, but which come from, in reality, from the European Convention of Human Rights. I will give you only one extremely important example, which is the interpretation of the concept of provided for by law, and a permissible exception which is provided for by law, which is the mirror of the expression in accordance with the law that we find in the European Convention of Human Rights. Well, this is extremely important because some people said, for instance, that limitations to the powers of the government for surveillance can only come through an amendment of 5772. That it is not possible, for instance, to introduce limitations or to create the DPRC or whatever without using a statutory avenue, without the Congress adopting that. But the case law, not only of Strasbourg, concerning the interpretation of in accordance with the law, but also of Luxembourg, the very clear case law is that it is perfectly possible. It is perfectly possible to introduce limitations to human rights and safeguards for this limitation using non-statutory means, as far as, of course, some very important conditions are met, including the fact that this must be binding. So, from this point of view, I think that it's very important to define a little bit in which legal framework, what is to set the scene of what we're talking about. Thanks a lot.
Thank you so much to you, Laura. You mentioned a lot of different topics, and I think the question of work quality is very interesting. So we are definitely going to research that. But I would like to move to Bianca first and talk a bit about global context, because as we all know in the Brussels bubble, we are often quite self-referential when it comes to our regulatory framework. I think the same issue is prevalent in DC, so we only care about our great ideas. But it's not only the EU and the US that tackle these problems of data constraints. It's a much more global question. So, Bianca, could you put this whole EU-US data transfer issue into the global context?
Thank you, Adam. It is on, right? Yeah. Thank you, and thank you again, Nikolai, for your presentation and for your paper. So indeed, just to zoom out a little bit and look at the bigger picture of which this discussion forms a part of. So huge transfers of personal data around us in our daily lives, and the concern transfers from the EU to many other jurisdictions, not only the US. So we should perhaps be talking more about global data flows. It's really worthwhile, I think, taking into account different cross-border data transfer models that are emerging as countries around the world update or implement their data protection laws. My colleagues in the Asia Pacific office have just released a report on navigating cross-border data transfers in the Asia Pacific region. And this really highlights, I think, the substantial developments in regional and international initiatives to promote interoperability between data protection laws. So it's interesting to see already the shift, considering the fact that countries such as India, for example, that only 2 to 3 years ago were still considering data localization efforts. But we seem to have seen a shift away from that trend and into interoperability and facilitating this global digital economy. We can also see the shift quite clearly in initiatives such as the Global Cross-Border Privacy Declaration. Currently, Canada, Japan, Korea, the Philippines, Singapore, and the US are participating in this. The declaration essentially establishes the global CBPR forum, and their aim is to establish an international certification system based on the APEC cross-border privacy rules. And again, to support the free flow of data while protecting the privacy of individuals. Another interesting development that I think is worth noting is Japan's efforts to promote the concept of data free flow with trust. This is actually quite a broad vision for the free flow of data while ensuring consumer and business trust. So really based on trust and privacy, security, and also intellectual property rights coming very much into the discussion. And this gained momentum in international fora after it was initially announced in Davos in 2019. The G7 in 2021 adopted a roadmap for cooperation on this. It's really gaining traction and an action plan for its promotion. Most recently, the OECD further developed on the concept in white papers released in 2022 and 2023. And even in the context of the EU-US data privacy framework, we've seen that it's been a somewhat moving target and created a level of uncertainty. It continues to remain a moving target into the future, shown already just by the simple fact that we're having this in-depth conversation today. So we need to keep monitoring these conversations and developments globally and ideally take a proactive approach. So with an overarching question of what will create trust and durability, as well as a high level of personal data protection. And in this sense, it's also been interesting to see that a move towards trust and interoperability has also been taken somewhat by the US, not only in international fora that I described, but also in its own approach to the EU. So shortly before the adequacy decision was published on 3rd of July, the US Department of Justice released the memorandum in support of designating the EU together with Iceland, Liechtenstein, Norway as qualifying states under the executive order. So the memorandum determined that EU laws had appropriate safeguards indeed for signals intelligence activities involving US persons. Interestingly, and I quote, it said that the appropriate safeguard standard does not impose a rigid one-size-fits-all approach, but it does so in light of the importance of maintaining trust and confidence in the free flow of data in today's networked global economy. And it mentions to take really a more holistic approach. So I think I leave it here for now, and I pass back to you, Adam.
Perfect. Thank you so much, Bianca. And it's very helpful to talk about the international context and the theoretical framework, but I'm also very curious about the practicalities. And I think this is where Willie's expertise very much comes in handy to talk about the practicalities. So if I were a CEO of a multinational company, both operating in each single market and in the United States, would my life become more or less complicated thanks to Schrems 1, 2, and potentially what is your practical experience in this regard?
Thank you very much. Thank you for very interesting. So today's event is about the inevitable prospect of insurance free place and an exchange of use arguments that we use in order to challenge the validity of the new US adequacy decision, but please don't need to do a step back. To remind everyone in the audience what our organization's obligation, and we have good news in this regard, providing with the latest news of the French EPA on transfer to the US, and also shares some preliminary consideration on things to consider if you are currently reviewing your organizations that are transferred. So first, what does the adequacy decision mean in practice for transfers to the US? And for data exporters in the European Union, the distinction needs to be made between your importers that are self-certified to the BDF and those other transfers to importers who are not self-certified. For the first category, that is transferred to organizations that are self-certified to the BDF, then here is the good news: you have nothing else to do. No longer you have to make a very burdensome transfer impact assessment. You can rely on this tool and move forward with your transfers. For the second category, if your importer does not self-certify to the BDF, then the adequacy decision also has a positive impact. So you will still rely on a tool of Article 46, for example, the SEC or the binding corporate rules. You will still need to make a transfer impact assessment, but the conclusion of the analysis of laws will have to be adjusted with the content of the adequacy decision of July 2023, which is positive with regard to the level of protection for the personal data in the US. So this July 23 decision is a positive development for organizations in the EU. And it's important to say it. And on the other side of the Atlantic, if you are an organization that imports EU data in the US, there is, of course, merit to self-certify with the DPR because clearly this is the business differentiator. It helps business with European companies, and when you provide services to either public entities or consumers that you do benefit from some schemes in Europe where there is kind of subsidy, then being self-certified to the new DPR will, help you basically. So clearly, most companies in the US are trying to self-certify at the moment, and you need to remember that some of them were still compliant with the Privacy Shield. So for them, there will be like really minimum efforts to keep complying with the DPR. For example, the US Department of Commerce said that the process to self-certify and recertify annually will remain substantively the same as with the previous scheme, and this new DPR will not create new substantive obligation for participating organizations. So there are only minor differences to the supplemental principle. So differences in the way, for example, annual fees are paid, or you will need to bring a more detailed list of contact in case of privacy questions. You need also to provide more detailed procedure on your internal compliance. But to be honest, are minor changes to what were imposed to companies who certified privacy. So there are good news on both sides of the Atlantic, and it's important to remember this. Then, what did the French EPA say recently about US transfer? Because, I mean, of course, the CNIL has been extremely active on the topic. It is one of the authorities with Austrian EPA that were the first to issue enforcement action against the use of Google Analytics and to ask companies to stop using this tool because of illegal transfers to the US. And surprisingly, in March or May of this year, they sent a new wave of letter sending injunctions to French companies to stop using this tool. While we were a few weeks before, the adoption of the adequacy decision, and that there were a kind of constructive opinion of the EPA to say that there was significant progression in this new DPF, also not denying that there was some concern that could be monitored in the future. But the CNIL launched that wave of enforcement actions. And it was interesting to see what now they are saying after the adoption of this adequacy decision. So first, and this is something that Professor delivered today, the CNIL unfortunately suppressed from its website its guidance on Google Analytics. It acknowledges that now there is a valid mechanism for transfers to the US. They also published during the summer a Q&A where they answered some basic questions about this new scheme, and there are some interesting bits. So first, they fully aligned with the position, which was something they were paying for at some point, and then that they recognize in writing and explicitly that one of the key elements of this framework is the US presidential decree of October 2022, which aimed to strengthen the protection of personal data processed by American intelligence services by incorporating the principle of necessity and proportionality in the context of access by US authorities to data, and introducing a new independent and partial appeal mechanism to the election supervisor. So they recognize this in writing. And then there is one last bit which will really appreciate companies. They said that they are still allowed to sanction companies for past infringements. That is, for example, the use of Google Analytics before July 2020. So organization will appreciate this. Then I wanted also to come back on that initiative from Mr. Laton with the French MP, but also the commissioner at the CNIL, just to clarify that his action is in his personal capacity. So as a simple citizen of the Union, not as French MP, not as commissioner of the it is said to be a certain page brief with hundreds of annexes, where the most important arguments are related to the absence of the right to an effective remedy for data subjects, in particular due to the lack of transparency of the newly created data protection review board. He also claims that the EU-US still maintain the breach of the implementation of principles of the GDPR, in particular due to what he considers bulk collection of personal data, and there is no distinction currently in this memorandum between bulk collection of personal data and generalized and indiscriminate collection of personal data. And finally, he uses the rather procedural argument in his brief, which is related to the fact that the EPA decision is only available in English and should be translated in the official languages of Hungary. So
that's it for the meal. And finally, my last point is about what organizations need to take into account in adjusting their data transfer strategy. Because to be honest, organizations are tired of the innovations. After the Schrems 1 and Schrems 2 ruling, EU DPA made a kind of after sale of that decision. And basically, what they told companies is that they needed to incorporate in their data transfer strategy a change of paradigm. Because this was implied by the TGU decision itself. That is, in any instance, to consider first the existence of alternative. If there is any alternative to a transfer, you should not transfer. That was their main message based on Schrems. And then to adopt a rather extreme interpretation of the Schrems ruling, in particular when conducting the exercise of transfer impact assessment, which led some authorities to forget one of the options that was contained in the guidelines 120 regarding this transfer impact assessment exercise, which was the case where sometimes the outcome of the GDPR is uncertain. And if you can prove that there is no appetite for models in practice for access to the data which is being transferred, you may continue the transfer if you are able to document it. Clearly, this option, which referred to a very specific question of the guidelines and a section of the Schrems ruling, was completely forgotten when they started to adopt their decisions on Google Analytics. It was very difficult for companies to adapt to this evolving situation. I would say that some organizations that do process and data or are public entities, of course, made significant adjustments. And some of them really minimize the number of transfers that they were used to make. And in particular, with regard to the transfers to the US that were under a lot of scrutiny. And now the question is, were these efforts necessary now that we have a new DPF? And probably the answer is yes. This was not necessary. It was first, this change of paradigm is there to last. And you mentioned, the decision which refers to what we call the Schrems two-style effect. That is no transfer, but EU storage, but by a company who is subject to extraterritorial laws. And clearly, this doctrine is going to continue. It's going to last. So, this minimal approach to data transfer, which has been adopted by companies which are very much exposed to regulatory sanctions, I think was necessary. But clearly, with regard to transfers in the US, organization can breathe at least for some years, and it's important to anticipate what is going to happen and potential movement of the decision, but it's not a done deal. And we're going to talk in more detail about it. And then there is some time to do that.
Thank you so much, Willie, for outlining the practicalities so briefly. And it's clear that you wake up and go to sleep with these thoughts, and so the rest of the panel. But some of us don't, surprisingly. And for us who don't do it, we take a step back. It seems sometimes absurd that you have the United States and the European Union, two highly developed economies, great geopolitical allies, both in a military and political sense, and they seem to be going head to head against one another. Why do you think that is the case, and why do you think it's the EU-US relationship that matters to most, rather than what Jan also mentioned in her opening remarks? Putting it in the global context, data transfers obviously don't only happen between the EU and the US. What about China? TikTok has been coming up as a major platform that a lot of us in Europe are using. Why are we picking on them for Americans in this way?
Well, issue of course, and of course, it's quite interesting to see that there is this much focus on Western third, why we do share democratic values in this country, and there are other countries where the legal system are much more different than the US. And what is interesting to note, and we have done a lot of transfer impact assessment, but you need to look into the details of the local legal system. And if you want to have a slight check for the EPICENTER to have a positive conclusion, basically the assessment needs to meet 4 assumptions. The first assumption is the existence of a legality principle in local law, which is the notion that law regulates and constrains the behavior of public authorities. Think about some countries that do not incorporate the state principle or just do not understand that from a cultural perspective. The second assumption is that the access of the government to personal data can be limited by law. The third assumption is that individuals will have rights against the government and citizens object to the decision of the government or have legal remedies through which they can claim their rights. And the fourth assumption entails the idea that there is a separation of power, meaning that an independent judicial branch exists, controlling and restraining governmental access to data. This is a very European way to think. And if you tell this in some countries, this will make no sense legally and culturally. And in many cases, it's impossible to have a positive conclusion. And it is true that for the moment, all the attention has been focused on the US first for obvious political reasons, and then because there were an adequacy decision toward the US wanted one, the EU wanted to do the US one. This was not existing with other countries, particularly in Asia, so these issues have not been raised before. And probably the question also is, now that we have a new GDPR, of course, there is these actions which are being prepared, but will the attention focus on other countries in other regions? And what will the EPA say or enforce? And we will see if, they go in the extreme direction to implement their positioning with regard to other regions of the world. So enforcement actions seem to indicate that for some countries that is the way they are going. And for other cases, what we see is that they are not, really examining the situation closely, but they want to go to that step. So we'll see, but clearly, I'm sure that some people that are observing the issue are very much surprised of all the time we spend on dating this, frameworks and blaming the US for that they are doing.
You want to comment? Yeah, very quickly. I think, from here this argument, I think it's legitimate to ask questions about especially the United States. Almost all of the companies that we use are American, or the cloud from big cloud providers are American, the social media, etc. are American, or so most of the data will be to the United States. Perfectly legitimate to focus on this. And saying that nobody cares about TikTok, I think it's entirely wrong. First, there are a lot of questions about both in the United States and the EU. By the way, TikTok did a lot of things. They announced, that they created, expanded their billions to create data centers in Europe and store the data in Europe. So I don't think, of course, one should really take care of the risks of transfer to countries like Russia, they're still, but I don't think that this is the main issue. It's a little bit normal also for people to focalize on what the real world, and the real world is that most of the data for the United States.
Sure. Maybe I already touched in this presentation about the verdict of Schrems 2 that SCP outlines that third countries cannot be expected to have the same high level of data protection as the EU, right? But in effect, isn't this the goal of many in the Brussels bubble? If you're looking at the European Parliament and the European Commission, we often talk about, exporting our regulatory frameworks to other countries across the globe. So if that's, the goal is essentially to expand the regulatory influence of the EU well beyond Brussels. Does this whole discussion around Schrems help us? Do you think that kind of Brussels effect is being destroyed if we expect the maximum compliance by third countries? Yeah, that's what I comment on.
So I can talk a little bit about what Nikolai also mentions in his paper towards the beginning around the way in which increasingly the language of the executive order sort of mirrors EU law. And in particular, in terms of language, we see, for example, key principles of necessity and proportionality, which have been much discussed and which Professor Pisaki is much more expert in than me. But the executive order also seems to go further than this with reference to legitimate objectives, very reminiscent of legitimate interests in the GDPR, and also for the need of intelligence agencies to conduct this balancing test, essentially on the basis of three possible conditions. One, the priority advances one or more legitimate objectives as listed in the executive order, and indeed the order provides a list. Two, it was neither designed nor is anticipated to result in signaled intelligence collection for a prohibited objective. And three, was established after appropriate consideration for the privacy and civil liberties of all persons. This is really interesting, and this balancing process would, and I quote the adequacy decision here, notably ensure that privacy considerations are taken into account from the initial stage where intelligence priorities are developed. And for those in the room familiar with the GDPR, and it's kind of nod to privacy by design concept, and an even bigger nod to this delicate balancing act that seems to be founded on finding solutions to balancing fundamental rights or civil liberties on the one hand, and fulfilling legitimate national security objectives on the other hand. But then, of course, one might ask, what does appropriate consideration for the privacy and the civil liberties of all persons mean? How can it be measured? Are we talking about an impact assessment? Exactly what will this look like in practice? And this also remains to be seen. But to get a hint of this, it's also interesting to look at the intelligence community procedures from the 3rd of July. Again, prior to the publishing of the adequacy decision, the aim of the procedures is to implement the requirements of the order and therefore of the EU-US data privacy framework. So each intelligence community agency has a set of certain procedures which delineate approaches with regards to data access, data security, quality, accuracy, bulk collection, data minimization, and so on. So we see the beginning of a shift from principles to practice, which would, in a possible Schrems 3 case, likely very much be taken into account and assessed by the court. Will the court deem these steps as sufficient to show essential equivalence? Only the court will be able to judge on that. But more broadly, to go back to your question, I have also seen, for example, GDPR Article 5, key principles such as data minimization, risk limitation, data retention, and so on, also making now part of US state laws, such as California Privacy Rights Act and Utah Consumer Privacy Act, just to name a couple of them. So we are seeing a kind of level of convergence here, also in terms of principles.
So our regulatory export system seems to be working. Nikolai, do you agree with that?
Well, I think that what Jens said is very much true. But think about what happens if, after going to all that travel, then the court said that it's not good enough. Right? What kind of a signal does that send to any other country that might be thinking that they are willing to adopt the features or to have adequacy?
Are we talking about Japan, South Korea?
No, South Korea, yes. but there are many other countries in the world that don't have adequacy decisions. There are a few adequacy decisions. But so the point is, if for someone who cares, especially about that aspect of leadership and in terms of regulation and then the Brussels effect, it would potentially seriously undermine it if you see the organization all the effort and then just at the end of the day just be told, no, that's not good enough. So many other countries may just then reasonably conclude that okay, so it's not worth trying because it's impossible. So yeah, unless we adopt EU law, which is kind of may sound very realistic in many places of the world. So that's probably another way to for the Brussels effect to spread.
Yeah. Promised you that we're going to return to proportionality, and I think that's an interesting discussion, right? Because that's one of the arguments that if there is the US administration that's already exercising proportionality when it comes to data collection, then things are fine. But if the EU is a lot more superior in that regard, then we have a problem. So, what's your assessment? Is the US administration already matching the expected levels of proportionality when it comes to data collection?
Well, you how many hours? 10 hours to respond to this?
Or the audience may be angry because the champagne is already in the back end.
You understand that there are a lot of issues, and as I said also earlier, under the label of proportionality, in reality, you have a lot of different things that I proposed during this conference in Luxembourg last week. A kind of a way that could permit, based on the EDPS guidance on assessment proportionality, to better discuss the different issues. For instance, we have the first use provided for by law these safeguards, despite the fact, as I said earlier, that have not been adopted by a statute. And the answer, I think, on the basis of the EU law is that non-statutory reforms, if they're binding and if they meet which they are, and if they meet the requirements of accessibility and foreseeability, then should be considered enough. And we have four other requirements, and reality proportionality is just one of them. And we think the concept of proportionality, you have a lot of different things to examine. Let me take just for instance one of the issues that was raised earlier, because I have thought about it, which is one of the 5 elements is that the restrictions to Article 7 and 8 or to Article 47(1) must genuinely meet objectives of general interest recognized by the Union. And you know that there was a big effort for the first time in US surveillance law to try to capture these and to define with precision the legitimate objectives which would permit surveillance activity. So if you read the new executive order, you will see that we introduce 12 legitimate perspectives, which could, legitimate objectives, which could permit to undertake SIGINT activities. Now, I would have a lot of comments, but I was thinking precisely, I was reading when the EU came out, I was reading this and said, could this really meet the requirements of EU law? Well, a lot of these legitimate objectives are concern specific threats to the national security of the United States as defined by the United States. For instance, threats which are posed by foreign organizations, including international terrorist organizations. I don't think that the court will have any problem with this, the Court of Luxembourg. Threats which are posed by terrorism, threats by foreign military capabilities and activities, espionage and sabotage. So these are direct threats to the national security of the United States. And I don't think, on the basis of the case law of Luxembourg, that there will be any problem, because the court has said several times, even the retention case, that we will have these kind of specific threats, then we can accept not only it's a legitimate objective, but also it should be taken very heavily into consideration during the balancing text within the context, strictly speaking, of proportionality. But then, if you take the first legitimate objective, this is what made me think a lot about it, and this is why I said that we really need to think hard about these issues, avoid shortcuts, and avoid dogmatic approaches. Let me share this thinking with you. The first legitimate objective, the very first that we find in executive order which justifies surveillance activities, is the following, I quote, understanding or assessing the capabilities, intention, or activities of a foreign government, a foreign military. I repeat, understanding or assessing capabilities, intention, or activities of a foreign government, a foreign military. And blah, blah, blah. I will not continue because it's long. So I said to myself, just a second, here we have a legitimate objective where you can take surveillance activities without a specific threat to the national security of the United States. It looks much more like what we call affirmative foreign intelligence information, to gather information about foreign activities of foreign military, for instance, foreign country, without a specific threat. You don't have to justify that this country, the military of this country, poses a specific threat to the national security of the United States. So I said, could this pass the test of Article 52, paragraph 1 of the Charter and be considered as a legitimate objective under this? Well, as a matter of fact, I thought about it. At the beginning, I was very reluctant to accept it. But then I said, what is intelligence about, after all? Is intelligence, intelligence is the second oldest profession, isn't it? So we have been doing this for a long, long time. And as a matter of fact, we should not forget that this executive order, of course, it was adopted in order to address the issues discussed with the Europeans, but at the same time, this is the legal framework for their intelligence, for their external intelligence. So if they don't put there some things which are defined sometimes in a general way, as a matter of legitimate, they will not be able to carry it out. It will be illegal. So and then I said, we had the war in Ukraine. And I said to myself, okay, if they don't put this means that they cannot undertake surveillance activities in order to see what the Russian military are doing. They would have been entirely unable to provide Ukraine with all this intelligence, which was absolutely essential in order not only to be able to defend themselves against the Russian blatant aggression against Ukraine, but also afterwards to undertake counter-offensive. So one should say, just a second, okay, it's not a specific threat. It was not the United States that would be invaded by Russians. It was, but if you don't introduce this inside a law which defines the legitimate objectives of surveillance, then we don't do intelligence anymore. And I really think that we need to think hard about it. And not only this, because as a matter of fact, if you see the case law of the European Court of Human Rights, for instance, here in the Central for Advita case, the European Court clearly said about the Swedish intelligence legitimate objectives that it is undisputed that the impugned signals intelligence regime pursues legitimate aims in the interest of national security by supporting Swedish foreign defense and security policy and identifying external threats to the country. And more generally, we see that the courts, including the Advocate General and Schrems too, need to have a more flexible approach on this issue. If you go even further, you will see that this legitimate objective in reality, if you analyze it in the context, in the specific context of US-EU relations, you might think now that I'm entirely visionary, that I forget Snowden and all these things, but it is clearly stated in the executive order that intelligence activities against a foreign government or a foreign military can only be undertaken in order to protect the national security of the United States and of its allies and partners. So, one, being a little bit optimistic and thinking that friendly states should not spy on each other, and I have also presented in the past some ideas about non-spying treaties, and we could have a whole discussion about this, but one should think that eventually the ones that would be targeted by this legitimate objective will not be the Europeans, will not be the EU member states, hopefully, but on the contrary, they will be beneficiaries, European states, of this kind of intelligence. just one last point. If you read, I referred before to, it's interesting to read the other adequacy decision. If you read the South Korean adequacy decision, you will see that it refers to rather broad terms such as anti-Korean or anti-national activities. And this has been accepted. There was no problem with this. So, once again, we should be, I think, a little bit, we should think about these issues, not be dogmatic and say, oh, it's not a specific threat, and it does not seem to, the data retention cases are different. There are some similarities, but are different. They're not the same issue. So we should try to do some thinking about these issues, because these issues are hard.
But do you think then that this whole debate revolves around really the definition of legitimate national security concerns and kind of the distinction between how Europeans understand it and how Americans understand it since 9/11, right? And if there is this kind of distinction between the two, I wonder whether there will be some convergence in the future, or whether it's going to become more and more, divergent. Willie, do you have some thoughts regarding that?
Well, we will still be two very specific and different regions of the world with the different cultures. So these concepts, we will never interpret them the same way, and we need to acknowledge that. And I mean, as you can say, in Schrems 1, nobody requires identical level of protection. They require a kind of similar, essentially equivalent level of protection. So what now we can say is that over the past 20 years, our legal systems have become more and more convergent. And what is in the October 2022 presidential and executive order, and the other implementing regulation that comes with this new court, the protection review court, do include some specific references to respond to the concerns expressed by the Court of Justice of the European Union in Schrems 2. So my only point as a practitioner, and I'm thinking about my litigation colleagues that will defend the invalidation of this new GDPR, is that this will obviously be much more challenging than a few years ago. Because now you have a whole set of regulation which do mention some concepts which are really European, like necessity and even proportionality, even though it's interpreted as reasonableness in the US. And you do not only have this. At the moment we speak, all agencies in the US are adopting and publishing internal procedures to govern access to data. So the claimants will need to go through all of this regulatory framework to say that they do not comply with the essentially equivalent level of protection. So this is why I really think that it will be much more challenging next time, and that of course we will still have, some different views on how to interpret some terms, and that's the life of any lawyer. When we do sometimes translate legal documents, some have no equivalent in our legal system, and we just find the right way to explain it. And that's basically the same that we are doing with this issue of transfer.
So you will keep on having a lot of work in the future. I know that we have an audience full of experts, so I'm very keen to throw the mic to you for comments and thoughts. But maybe one last question before I do that, because Nikolai touched on the topic of effective redress, which seems to be a very tricky one, given that it's a sensitive intelligence work that we're talking about. Can you see a reasonable way of providing that type of effective redress for citizens who feel impacted by this? Do you have thoughts on that?
I think that there were very spectacular developments concerning the redress. You know that we work very, very hard with people's work on this topic, and we published long ago two articles on this. And basically what we did is that we tried to identify the criticisms against the privacy shield, which appear not only in Schrems 2, but also in the TTP positions, the TPS, etc. And we tried on this basis to make a proposal of how this could be eventually fixed while taking into consideration some, for instance, constitutional constraints in the United States, where contrary to some suggestions that have been made, it's not easy for several reasons that we explain in detail in our article to give this power of examining, this kind of redress requests to federal courts, while still eventually providing for an opportunity of 50-minute intervention federal court. Now, I think that the big issue, there are a lot of issues, of course, concerning this. There has been creation of this data protection review court. We think that the way it has been created gives absolute guarantees that it is binding among all the international security agencies. The activities of the DPRC will also be subject to oversight by other independent bodies like the PICLO, which will publish reports. We will receive the decisions, the argumented decisions, in which we publish reports. So, for instance, it was said earlier that the president could overturn. I don't see legally how the president could overturn the decision of the DPRC. We have a precedent here, which is a decision of concerning the case of Nixon in the United States in 1974, where precisely there was a creation of independent prosecutor for the Watergate scandal, and the president tried everything to stop this, and the US Supreme Court said, no, it's not possible, because as far as this regulation, there was a kind of self-limitation of powers, both by the president and the Attorney General. Of course, they can, anytime they want, they can put an end to this executive order, to the DOJ regulation, but then immediately the whole regime will collapse, everything will collapse, and this will not happen, logically will not, cannot happen. So as far as we have this self-limitation, but both by the executive order and by the regulation by the Attorney General Department of Justice, this is binding on all the executive, including the president. And if something like this, I mean, entirely out of the realm of imagination happens, the PICLO will be there to control. I mean, normally, if you have this oversight, either the United States is going towards a dictatorship where you have democratic institutions and independent bodies which pretend to do things and in reality they do exactly the contrary, or you have to trust a little bit the legal system. I mean, we cannot enter into this kind of paranoia thing. I think that on the basis of existing law, we have enough guarantees today about the independence of this body, and this is what has been requested. We're not at all the ombudsperson, that there have been very spectacular developments, and from this point of view, we should eventually be optimistic that the system, now is it going to be used? Let's say, because even in Europe, you have all this oversight. We stopped $1 trillion transfers. In reality, if you see what's going on in the UK or in France or elsewhere, you will see that it's a very limited number of exercising this redress request. And very often it comes from the same persons who do it in a repetitive way, and some oversight bodies are so upset that they start declaring it inadmissible because it's repetitive, 20 years, by the same person. And as a matter of fact, this is extremely important to exist, but I mean, okay, we have created this mechanism. We should also take into consideration the real practice of this mechanism in the different countries which have independent oversight and right to an effective remedy. And then we should say, okay, are we going once again to stop several $1 trillion worth of which permit to fight also a vaccine against COVID, because it's all the scientific research, it's everything that you're sharing between pharmaceutical companies or other companies between the two countries. Are we going because, for instance, we think that the president could secretly do something illegal? And I don't know if it works exactly like this.
Do you agree with this assessment, Willie?
I'll just add one sentence about all the discussions we have on effective remedy in relation to surveillance of individuals. So in the real life, when there is a surveillance technique, you just don't know. And you know what? In almost all countries where there are legal regime for this, there is a criminal infraction if someone discloses the existence of a surveillance technique. There is this criminal offense in the French criminal code. So you just don't know, and sometimes you suspect that you have been subject to surveillance if you are subject for many years to indirect consequences. And it's very difficult to challenge it, even in Europe. So, I'm talking a lot about effective remedy, but in our countries, it's very difficult to implement that. Also, legally, there are recourse actions.
So the practicalities essentially don't enable that. We have roughly 15 minutes left till our champagne popping movement. So if there are any questions in the audience, now is your time. If you could kindly introduce yourself, your name, organization, and then who you have the question for, that would be much appreciated. So over to the audience. Everything is clear. Okay, you guys went into fantastic details. That's the lady on the list.
And I'd like to ask a question, maybe a general question. So, as we in EPICENTER just told us, do you really think that the GDPR is applied even in our countries? Because we talk about data protection, and Europe is broad because the US innovates on the technological side, but Europe innovates on the regulation side. So Europe is proud about GDPR. But in fact, is GDPR really is applied even in Europe? What I mean is governments have all your data. The Act on Artificial Intelligence has been signed, ratified, and all institutions are now talking about sharing their data that means our data. All commercial enterprises have our data, so at the end of the day, everybody has, in fact, our data. You have cameras in the streets, in the metros, in the public, everywhere. So our data are really public. And so maybe it's time to debate for open data, because this is the case.
So thoughts on GDPR? Yeah, Cass, do you want to pick us up?
Well, that's a very good question. It's interesting to see how the GDPR has been progressively implemented. To answer your question, yes, the GDPR is being implemented in Europe, and it clearly applies to legal, either private and public entities. And in some countries, there are enforcement actions against public entities. This is the case of France, for example. Also, some basic precautions that we have with personal data, of course, are subject to a balance between different fundamental rights, and it's clearly the case when it comes to surveillance. In our countries, we have very intrusive surveillance laws. There are some limitations. I will not be able to tell you if they are completely effective or not, and if people really use the recourse actions, but we have a law that tries to make a compromise between the right to data protection and also other fundamental rights, like the right to safety, to go, and this is a very difficult exercise. What is interesting to note is that with the safe harbor invalidation and then the privacy shield invalidation, the GDPR has really been instrumentalized to impose as much stringent requirements on companies overseas than on European companies. And on the objective, which was assumed, I think we partially failed. Because if you look at the companies that suffered the most of this enforcement human action, it was mainly, to be honest, the European data controllers that received injunctions to stop using certain tools that were critical for their marketing activities and for their business, and with never a possible alternative, with a denial of the existence of real-life alternatives. And we basically ask companies to reach an objective which is a purely political objective. And what you are currently saying is the adoption of new texts, the DNA, the DSA, the DGA, the DA, and they all are, the illustration of the willingness of the European Union to take back control on the data. And we use regulation as a tool to achieve this, while in some countries, regulation comes after industry initiatives. And this is what we stand out from the behavior of other countries in the world.
Thank you so much. Are there any other questions in the audience? If not, then I would very much like to have the panel as closing remarks essentially assess the predictions, what's going to happen in the next 2 years. So Mikolai kind of outlined not an optimistic scenario, to put it mildly. If some of these data transfers stop between the EU and the US, obviously that would have a major impact on all of us. But what do you think the Schrems process will be over the next 2 years? What would be the ideal outcome that you would like to see? But also, what do you think the likely outcome is going to be?
Well, I can only say one thing, that the road will be long. There will be, we don't even have this has been mentioned, this direct challenge for invalidation by the French MP. Which normally, if we follow, it was a very clever litigation strategy by Philippe Breton to take advantage of this period of 2 months. And to request to challenge directly. There's nothing to lose after all. But it would take into consideration the case law of the courts and the fact that the European legal system will introduce the different possible applicants, categories of applicants, in order to exclude the possibility of an actual popularis. One should say that normally this will not be successful. This will not be successful. Even though he's using the argument that in any case, in one way or another, the court will control, so it's better to control it from the outset. This will avoid to have to wait and to waste money with other procedures. But normally on the basis of, and Joe Jones published a very good AIPP paper on this. Normally, this should fail, and he will not pass the standing test, which means that instead of having Tom 1, we're going to have a Schrems 3, because Schrems is using another litigation strategy, which is to challenge his transfers, the transfer of his own personal data. So it's much better in order to have standing by specific companies until now it has been met, and now we're talking about Austria. Let's wait and see what will happen. And then you have this referral to the court, which is a way that has already been tested and should be also, of course, normally, let's wait and see, but should be a good litigation strategy with more chances to be examined on the merits. The road to this will be long, and my only wish is that we'll take advantage of this period in order to think about these issues. I try to offer some of my own personal thoughts, and Nikolai also and the other panelists greatly contributed to this effort of clarification. I think that we will need this expertise in the way to Schrems 3, we really need an informed, good decision where we will clearly separate the different issues and we will think about them. We should avoid intellectual confusions. It's extremely easy. We should avoid shortcuts. And we really need to do the hard work of thinking about these issues. And from this point of view, we'd like to thank you very much for the two think tanks today that organized this great panel.
We definitely did a lot of thinking, and I'm sure that there is more to come. Bianca, what's your assessment of the timeline and wishful predictions?
Thank you. So I really find it quite impossible actually to predict how this is all going to play out, but I do think that it would be really interesting to have this conversation or a conversation around EU-US data flows in 3 to 5 years. I'd be curious to see if we're having a very different conversation. But I would just like to end actually on what Nikolai essentially started with, which is that really our daily activities depend on data transfers, international data transfers. If they were to stop, it would be very difficult to function in today's societies as citizens, individuals, organizations, and the landscape of cross-border data flows is very much multidimensional. They do not only flow from the EU to the US, but they are global in nature. So I really hope to continue to see all stakeholders, working together and collaborating so that data transfers have these strong safeguards applied in practice and that protect people's rights. And just to monitor globally the fact that a lot of work is being done on model clauses, certifications, international codes of conduct as possible means to continue facilitating cross-border data flows, and also to continue monitoring just the fact that data transfers have really entered this intergovernmental and political level of debate that is going to continue developing, I think, increasingly in the following months and years.
Thank you so much. Willie, you have been part of some related court cases in the past, so would you dare to make a more concrete prediction?
Well, just because I have been part of some proceedings in the past, I cannot give you seriously a prediction of what will happen.
They're conservative panelists, no predictions.
My hope is that it will be validated, but to be honest, we just cannot exclude the fact that the DPF is invalidated for a certain time, and I'm sorry to say it, but that's the truth. What I'm certain is that it will be much more challenging for the claimants to, prove that it is invalid, but the risk remains. And from the conversations I have with the organizations that I assist, the only advice I can give them at the moment is first fully identify what are their obligations now that the DPF is in place concerning US transfers, and then just look at the positioning of your organization. If your organization is exposed to the regulatory risk, because, for example, you are currently subject to investigations, or if your business model involves processing of personal data, and in particular sensitive data like health data, of course, keep a lot of precautions and anticipate the potential invalidation. And some clients who are very risk adverse, even though they are going to move forward with providers in the US who self-certify, want to keep having SCCs and DTIA ready in case the new DPF is invalidated. And for the others who are either not exposed, then what I see from their behavior is that they want to use this new freedom to send data to the US to the fullest extent. And probably they will just try to choose and privilege providers in the US who are self-certified, and will try not to do anything more.
Thank you. I'm going to pose an even more difficult question to you, Nikolai, because you outlined kind of the doomsday scenario of stopping the US data transfers. What's the likelihood of the doomsday scenario, actually? I'm optimistic, right?
Well, I think that the doomsday scenario is very likely if the decision is invalidated. So are you asking me what's the likelihood of the decision being invalidated or? Well, I think, and I agree with everyone else, that the case for the validity of this adequacy decision is stronger than during the previous challenges, right? So it is the job for the claimants or the challengers is more difficult now than it was in the past, and yes, it will. The public and academic debate will probably have some impact as well. But I really don't want to be in the situation where of this doomsday scenario, because I think that there's one question is what about the companies that use service providers from the US, like cloud service providers and so on, and there's that B2B aspect, but if you're a company, an American company that's B2C, that's providing services directly to consumers here, then you can't really divest from yourself, right? So, and if the standard is that no data localization can work, if there's a theoretical possibility of access from compelled access from America, then well, you can't provide services. Then you can't provide services. We're looking at like this doomsday scenario is really something like a de facto prohibition of American digital services in Europe, which is just insane. So so hopefully it will not come to that, right?
We have the hopes indeed, and with Swiss military precision, we have about 60 seconds left. So it's my great pleasure to thank Theodore, Bianca, Willie, and Nikolai for the fantastic conversation. Thank you so much for the contributions and the attendance as well. I'm sure that this discussion will continue in the future. Nikolai will come up with this new paper published by the International Center for Law and Economics in a couple of weeks. So please do make sure to follow us online and keep in touch. But for now, at least we can agree on one thing, that Europe is still amazing when it comes to food and drinks. So we will provide you with some amazing French bubbles. I hope you will be able to stay. And thank you so much for joining us today.